A very warm welcome to everyone. Today, I, Reeya Khanna, an intern under Lexis and Company, am here virtually to express my views on bail rights. What is bail? Bail is basically a temporary release from the prison. When a person is arrested by the police under certain circumstances and situations, the arrested person can be provided bail, that is, a free chit to get out of the prison or a get out of jail card until the trial of that person starts or takes place. Various sources have defined bail as Lexicko has defined bail as the temporary release of an accused person awaiting trial, sometimes on condition that a sum of money is lodged to guarantee their appearance in court. Cambridge Dictionary defines bail as an amount of money that a person who has been accused of a crime pays to a law court so that they can be released until their trial. The payment is a way of making certain that the person will return to court for trial. Macmillan states that the bail basically means to allow someone to stay out of prison while they wait for their trial after money has been paid as bail. According to the Merriam-Webster dictionary, bail is the temporary release of a prisoner in exchange for security given for the prisoner's appearance at a later hearing. As what is gathered from the above mentioned, in simpler words, bail is a written document granted from the court or the officer of court to a certain person who has been arrested by the concerned police as a result of his or her involvement or grievous doubt of involvement by the police authorities. Why is the bail provided? Most of the people who are arrested by the police opt for a bail. This is so because until declared guilty by the court, every person has the right to live the way they want to. Conditions apply. They also have the right to live out of the prison. Prison is a place for those who have been convicted by the court, where the court felt that they are guilty of the charges, as of in India, guilty beyond reasonable doubt. A person who is just accused and not convicted has the right to live freely out of the bars of the prison. This bond of bail has been created with the idea that no innocent should be treated the same way as a prisoner. In India, every person or accused until proven guilty beyond reasonable doubt is innocent and remains so until declared by the court of law. While the rights of innocent are important, it is also extremely important to make sure that the guilty do not take the advantage and escape from the clutches of the law. The bond of bail is to make sure that while the innocent enjoy their rights, the guilty ones do not escape. The bond makes sure that the bailee who has been granted the bail attends all the proceedings of the court related to his or her case. Now, what are the conditions of the bail? Not every accused person is eligible for granting bail. Eligibility of bail depends upon the nature of the accusations or the severity of the crime and its punishment, and the nature of evidence against or in support of the accused. Number one, while granting bail, the court has to keep in mind not only the nature of accusation, but the severity of punishment if the accusation entails a conviction and the nature of evidence in support of the accusation. Number two, reasonable apprehensions of the witnesses being tampered with or the apprehension of there being a threat for the complainant should also weigh with the court in the matter of grant of bail. Number three, while it is not accepted to have the entire evidence establishing the guilt of the accused beyond reasonable doubt, but there ought always to be a prima facie satisfaction of the court in support of the charges. Number four, frivolity in prosecution should always be considered, and it is only the element of genuineness that shall have to be considered in the matter of grant of bail. And in the event of there being some doubt as to the genuineness of prosecution, in the normal course of events, the accused is entitled to an order of bail. The Indian Law of Criminal Procedure Act, or the CRPC, the Indian Law of Criminal Procedure Code, or CRPC, talks about bail and its process and how it's obtained in detail. Section 2A of CRPC talks about bailable and non-bailable offense. Section 436 to Section 450 set out the provision for the grant of bail and bonds in criminal cases. A lot of judicial cases have talked and highlighted the topic of bail. For example, State of Rajasthan versus Balchand, All India Record 1977. Motiram and others versus State of MP, All India Record 1978. And Menka Gandhi versus Union of India, All India Record 1978, highlight the adverse condition of the poor with regard to the unjust bail system in India. Thank you.